Who has the better odds in civil litigation, plaintiffs or defendants? This is kind of hard to figure out. On the one hand, plaintiffs get to make their case first. This could improve their odds due to priming. On the other hand, judges and juries might remember those arguments particularly well that are presented at the end of a trial, and that's the defendant's time to speak. Today our guest is Keren Weinshall from Hebrew University. In her co-authored paper, she comes up with a solution to get at this problem. Keren, why don't you introduce yourself and tell us what brought you to this research question?
Hi, thank you. So, as you said, my name is Keren Weinshall, and I'm a professor at the Hebrew University. And what brought me to this question is my general interest in why and how judges make decisions. So I'm interested basically in the extra-legal factors that influences the law that they make. So it could be their personal ideologies, it could be public opinion. Sometimes it's the ideology of the judges sitting with them in panels, and often it's their biases. So judges are human at the end of the day, and well, as professional decision makers suffer from different biases. So legally speaking, the plaintiff, as the initiator of the claim, shouldn't have any advantage. If anything, perhaps there is a small disadvantage because usually in most countries, plaintiffs have to have the burden of the proof. So they have to establish their case with a preponderance of evidence. What we wanted to see is how it works in practice.
When investigating whether there is bias towards plaintiffs or defendants, there seems to be one fundamental challenge. We don't observe the true merits of a case. That is, you as the researcher don't know how a particular case should have been decided. And that makes it very hard to decide whether there is bias and which way it goes. Could you tell us anything about how you tackle this problem in your paper and what the main finding of the paper is?
That's a great question. You're right. There isn't any baseline where we can see, where we can study a bias from. There's also another problem of selection effect. So what we try to do is we try to utilize the unique cost regime in Israel and study just one aspect of biases, and that's biases in the cost-shifting outcomes. So again, we kind of center with just a small part of our question, and Israel has basically loser pays cost regime. So what we can do is we can place the substantial outcome of the case, who won the case, against the cost-shifting outcome, and then see whether prevailing plaintiffs or prevailing defendants win costs more than the other. So we provide a baseline, and we also deal with some, not all, of the selection effect. So what we did is we actually gathered and analyzed 3 original data sets to study this question. So one asks if there's a general cost-shifting bias in all civil decisions. That's a general data set to just see a trend. And then we centered on small claims, a data set only on small claims, and that's because small claims are easy cases between 2 individuals with no lawyers. So we basically hold any explanations regarding a gap between the sides or how much they pay the lawyers. And the third data set is a data set with claims, civil claims. Each of them has a counterclaim. So both the plaintiffs and defendant have an independent claim against each other, and this tries to randomize the role of the plaintiff, who gets there first. We know it's not true randomization, but we're trying to get close, and this, together with all 3 data sets, we try to face different methodological obstacles. Our findings are actually quite striking. We didn't expect them. We see a very high plaintiff effect. So plaintiffs receive costs, prevailing plaintiffs, much more than prevailing defendants, and at higher rates, at at higher amounts, both in absolute amounts and as percentage of the claim.
Thank you, Keren. In your paper, you find a pro-plaintiff effect. Plaintiffs are more likely to be awarded cost, and they receive higher amounts. Interestingly, however, all judges you interviewed claimed that they treat plaintiffs and defendants symmetrically. Why do you think this is? And based on your data, can you say anything about the mechanism that's driving the effect?
I think that's one of the most surprising results we had. So we were able to interview 10% of active civil judges, which was really lucky. And we got the same story from all of them. They all said that the legal standard in Israel is loser pays, and there's complete symmetry between prevailing plaintiffs and prevailing defendants, which was obviously not the case. So first of all, I think none of us, it's a bias, right? So we're many times not aware of it. And I think there's some structural features of cost shifting that strengthen this implicit bias, so they don't really feel it. So one thing is that they have total discretion and very little information to decide with, and that's something we saw in the interviews. Their decision making on costs are intuitive. So we asked them, how do you decide if to shift cost and how much? And basically, I'm quoting one judge saying, it's a sense of expertise as a judge, very intuitive, which fosters this bias. And the third thing, it's unreasoned. So the decision whether to grant cost and how much is basically, in Israel, unreasoned. It's just the either right, cost will be shifted at a certain amount or not, never explaining it.
Your paper establishes that plaintiffs fare better in Israeli civil courts than defendants when it comes to cost allocation. What do you think are the policy implications of these findings? What do we do with this? And also, to which degree do you think this finding applies beyond the specific context you investigated?
I think that in order to talk about policy implication, we have to think what our results mean in studying biases in substantial case outcomes. Because we found, as I said before, a pro-plaintiff bias in costs decisions. This might not reflect a bias in actual substantive decisions. It might even be the case that the bias is pro-defendant. Some empirical studies show that the burden of proof for a plaintiff to prove their case is actually 70%, closer to 70% and not 51%. This means that a plaintiff that proves his case below the 70% threshold but above the propotency of evidence might not have to pay costs. So the first policy implication is actually study more the question of substantial legal outcomes and the possibility that there is a pro-plaintiff or pro-defendant bias in them. But there are some things we can do about cost regimes. So I think, first of all, there is a need to write guidelines for judges on how to rule costs. And that they do need to rule costs and that they have to reason their decision. I think these guidelines would lessen the implicit bias that we see in Israel.
Dear Keren, many thanks for this interesting work and for being our guest today. If you like this episode of the video log of the Center for Law and Economics and don't want to miss future episodes, hit the subscribe button below. Thank you.